Okay, I think it's working to go live on YouTube. Okay, really good. All right, we will get started. All right. Well, thank you everyone for being here today. Uh, Thank you for being part of the Startup Symposium presented by Pismo Ventures. My name is JJ Richa, and we've been doing these symposium for 5 years now, four of which have been life science, where we have life science only symposiums, and also a non-life science only symposium. The first year we did this, it was all combined together, but we split them after that. So this year, for the people that had just joined and did not join the previous expert panel that we had, we had 92 companies that joined us for this symposium, all life science companies. We put them through our filtering process, some automated, some not, and we ended up with 35 companies that were selected to go to a selection committee, and the selection committee met on Friday and selected companies that will be presenting to investors on demo day. Since we had more than 10, we split them into 2 days. One is going to be Thursday this week, May the 23rd at 12:15 p.m. Pacific time, and then the next demo day is going to be on May the 29th at 11:15 a.m., starting 11:15 a.m. So make sure you join us for both days. And if you don't have a link for some reason, you should all have received links, and maybe multiple times. And maybe you got inundated with Zoom invites, but hopefully you were able to add them to your calendar. We have more. We had one this morning, like I said, expert panel. We have another one just right now, a webinar with Ken August, who he'll take it on in a minute or so. But we have two more for the rest of the day. Another expert panel, very specifically about tech transfers and university tech transfers and what it takes to really navigate that. And then one more after that, very specific to intellectual property. That will be at 1 p.m., I think, Pacific time. Yes. So right after this, there are two more. Thank you again. Ken, it's all yours.
Thank you, JJ, and good morning, everybody. It's good to have you here, and I'm delighted to be presenting. Pismo Ventures does a fabulous job of bringing companies and investors together, and it's wonderful to be a part of the team. And so thank you, JJ, for the opportunity. We want to talk this morning about some of the top corporate structuring issues that every startup, whether you're life science or not, have to be prepared for and have to be considering as you're putting your company and its team together. At the outset, I want to say this is an educational program for discussion only. It's not intended to be legal advice or a legal opinion for anybody that's watching, because all deals and all companies are different, and it's not a one-size-fits-all situation. So please understand that just by participating in this webinar today, there is no attorney-client relationship that's being created, and you should not rely necessarily on anything that's said today without confirming the accuracy and the adequacy of it for your company with your legal counsel. Having said that, the act of creating a company causes for entrepreneurs to have many different things that they have to think about, and where those decisions are important because they can affect the company's entire future. Some of these things include legal issues which are at the core of the company, and these decisions that entrepreneurs make can have a huge impact on the way the company operates in the future, on its ability to attract investment from investors at all, or under terms that the company will consider to be suitable for the company, and also can impact on the ability of that company to have a successful exit, whether it be an M&A exit or a public exit. These decisions that you make early on in the life of the company will continue to permeate throughout the history of the company. And so I want to talk a little bit more in depth about some of these legal considerations. And I'm encouraging all of you, if you have any questions, JJ is monitoring the chat. Please put the questions into the chat. And JJ, please feel free to interrupt at any time with a relevant question, or we'll take some at the end. But I'm hoping that we get a good, lively discussion going on some of these things that are important to you. As a general rule, though, the legal considerations that you want to think about, the very first one is the cap table. And a cap table, which stands for capitalization table, is simply a presentation. It's often in the form of an Excel spreadsheet that details the equity ownership of the company whose cap table it is. So if you're a corporation, it will be your list of shareholders. It will give the names, the date that the shares were acquired, the percentage of interest that you have. If there are different classes or types of stock, maybe preferred stock, maybe non-voting stock, then it will designate that. And it's a very, very critical legal record, one of the most critical that the company can have, because it is the final dispositive document proving the ownership of the company by its equity owners. And absent evidence of manifest error in the preparation of it, these tables definitively say who may vote, how many votes a person has, and other aspects, including the valid issuance of the equity, the transfer and assignment of the equity to other people, and other things relating to the ownership of the company. So for that reason, they must be complete and accurate and up to date at all times, because it is a critical corporate record. That means that companies should, as a best practice, ensure that one designated person, a specific person, for example, the corporate secretary of a corporation, perhaps a member of an LLC, but somebody specifically is designated to maintain and keep the company's cap table and be able to represent, whether it's to the government through the Corporate Transparency Act, whether it's to other investors or shareholders who are asking about ownership. They have to represent that what's contained in that cap table is true and correct at any given time. So it's very, very important. Now, one area where people can get into trouble with the cap table is by trying to sort of be too cute, to be too flashy in terms of the stock or the equity interest that that company is issuing. Oftentimes, companies will go through various rounds of financing, starting with a pre-seed round, which is generally a friends and family round, going up to seed, to Series A, Series B, Series G, and we've had clients that have gone all the way up to K or L. And each of these rounds, or each of these series of equity, we'll talk about shares in a corporation. Each of these series of stock, that's a separate designated class, has competing rights and interests against all of the other stock that's issued. So I advise clients, when it comes to the cap table, keep it simple. Don't make it too convoluted, too difficult, for an investor to understand, or for an investor to feel that it is subject to a large degree of challenge from the individual equity owners going forward. In this case, boring is better. You want a templated cap table that any investor can look at and immediately understand and feel comfortable with. To that extent, in addition to the corporate secretary who maintains the legal instrument, it's also very important to engage a financial person with experience in corporate finance to engineer the cap table in order to suit the company's financial needs. This might be a CFO, but it doesn't have to be a CFO. It doesn't have to be a full-time CFO. There are fractional CFOs that will come in on a limited time basis that can sometimes be less expensive than a full CFO and have great credentials and experience to bring to the table. Or it can be somebody else that just has been through capital raising before. Hopefully somebody that's taken a company perhaps from startup all the way to an M&A or a public company exit, so that they understand every level of the capitalization. But these people will help the company to determine how much capital is actually required to implement the company's business plan. You've issued a plan, you've stated a goal, you've said we have certain assets, certain intellectual property, certain concepts that we want to bring and commercialize, but how much capital is it going to take? And when in the process is it going to take that capital, so that you understand the level and the timing of funds that need to come in to continue to support what the company is doing. And another thing that experienced financial people will do is to help you to establish benchmarks and milestones that are often used to trigger when another round of financing is coming in or should be coming in order to support the company's activities. As I said, each series of stock, typically when a startup is formed, you initially have your founder shares, which are your very first shares that are issued to the people founding the company. And then the typical history or maturity of the company is they'll do a pre-seed round that is typically friends, families, people who are interested in getting the company off the ground to get to a proof of their concept, some sort of an MVP or other confirmation that the technology or the business model that they are implementing will actually work. And then you bring in more sophisticated levels of investors, which may be angel investors going all the way up to venture capital. And then in some cases, the company will file to become publicly registered with the SEC, and you open it up to investors who will purchase the stock on an exchange or in a stock market. But these layers early on, as I said, are individual designated series. And what that means is the board of directors will actually cause the issuance of shares that are typically preferred stock, and each class that has different preferences is given a separate designation. So your Series A, Series B, Series C, all the way up will often be where they fall in the waterfall of distributions or dividends that are made, where they fall in a liquidation scenario, and what kinds of rights they have, whether they're voting or non-voting. Some shares have multiple votes associated with them, whether there's a board right that goes with it, other different rights that go with the stock. each of these designated series has to be clearly spelled out. And that's done through an amendment to the Articles of Incorporation, which is the document that is filed with the state when the company is first formed, and then every time there's a change in the capitalization, whether it's simply increasing or decreasing the number of shares that are authorized to be issued, or creating additional classes of stock beyond the common stock, which is the generic stock that's first issued to founders when the company is formed. And so, as I mentioned, the way that the rights kind of spill over among different classes of investors is often called the waterfall. And that's in a distribution who has the right to be paid first, second, third, and so forth, all the way down the line. And that waterfall has to be monitored and has to be consistently applied every time the company has some sort of a liquidity event or a distribution or a dividend that it makes, even a dividend in kind, which is a payment of a dividend through additional equity of the company, has to be consistently applied in accordance with the designation that was filed with your Secretary of State to create that class or series of stock. Then the other thing that entrepreneurs have to consider, and where having the correct advice early on is very, very important, is those shares have to be validly issued in accordance with not only the applicable law, which is going to be the law of the state where the company was incorporated, but it also has to comply with the charter documents of the company. If it's a corporation, you've got articles and bylaws that combined give you internal regulations that you need to abide by. If it's an LLC, you have what's called an operating agreement. Partnerships have a partnership agreement. And these agreements, much like the bylaws, will dictate the different things that have to be done in order to approve the issuance of equity, or in the case of an LLC or partnership, the admission of a new member to the organization. Then those resolutions have to be approved by the board of directors, and to the extent that it changes the capitalization, such as a resolution to amend the articles to create a new class of stock, then those resolutions not only need to be approved by the board, but they also have to be approved by proper shareholder vote. And that meeting of the shareholders has to comply with all of the notice and other technical requirements for holding a shareholder meeting by that corporation, or a meeting of the members by the LLC, and so forth. The other thing you need to remember with respect to the issuance of securities is that all securities, and by security, I'm simply referring to a share of stock, an LLC membership interest, a partnership interest, sometimes a promissory note can be a security, especially if the note is convertible into some form of equity, options, warrants. All of these things are considered securities. And there is a federal law, which is governed by the Securities and Exchange Commission, or the SEC, which overlays the issuance of all securities. And then there is a state law for every state, which is regulated by the state agency that governs securities transactions in that state. So when you're issuing a security, there are filing requirements that have to be made with respect to every share that's issued, including the first share to the founder of the company and any other founders, and going all the way through these series of equities that are being offered to investors as you go down the road. You have to file a form with the SEC stating what was issued, and then you have to file in accordance with the state laws of every state where the recipient of those shares resides. So if I'm doing an offering of shares to investors as a pre-seed round of friends and family, or maybe some angels, I need to make sure that I have filed my securities documents in every state where one of those friends and family or angels resides. Because not only do I have to comply with my own state's laws, but I have to comply with the laws of every state where I am offering and selling securities, anywhere in the country. And sometimes foreign countries also will have their own securities rules. So if you're taking money from investors overseas, that needs to be looked at carefully as well. The reason that that's important is that in order to comply with the exemptions that people will rely on, exemptions from registration with the SEC. When you're a startup and you're starting to issue founder shares, you don't want to have to do a public offering document or filing in order to issue shares. So as long as you are issuing shares in a non-public transaction, and the states regulate, and the federal government also regulates what's considered a non-public transaction that qualifies. The most typical form of offering is under the SEC's rule known as Regulation D. And Regulation D is a set of exemptions to the registration requirement with the SEC. But that means that you have to have somebody advising you who is familiar with Reg D and can lead you to make sure that everything is done appropriately in the offering, so that offering will withstand the exemption and not be negated. So, for example, Reg D and any securities offering, for that matter, requires that no person who is unlicensed, typically by FINRA, which is the National Licensing Agency for Securities Brokers and Dealers, but nobody who is unlicensed to sell securities is able to help you to generate investors and receive any compensation at all, cash, shares, a vacation, and anything of value cannot be given to somebody who is unlicensed as a securities broker or dealer in order to make sales of your company's equity to investors. And what happens is, and I've seen this time and time again, people will say, well, I'm going to do that. I'm going to help you find some people, but we want to receive some of the equity ourselves, or some commissions based on a percentage of the amount raised. Any of these things, if it goes again to somebody who is not a FINRA registered securities broker or dealer, will completely destroy the exemption provided by Regulation D and its state counterpart regulations. And why is that important? Well, if the offering is destroyed, it means that everybody who participated in that offering could not legally do so. And rescission is the only remedy that will take care of that violation of the securities laws. But rescission is returning the amount of cash you raised from all investors plus a statutory interest rate. And the company may have already spent the money. So we've seen companies go bankrupt because a rescission requirement came up because they either knowingly or unknowingly paid compensation to somebody for helping bring in an investor, and they just don't have the cash to pay that rescission. And even if they do, if they have to give it all back, now they're left without the cash that they need to promote the company's business plan. So it's a very difficult situation, and it's something that people really have to watch out for.
Now, there's a question
Yes,
for you.
yes.
I didn't know this. I mean, that could be devastating for a company. That's oh my God. Um, but the question is, what type of shares need or should be given to a scientific board, advisory board, in an early stage startup?
Well, that's a good question, and to a certain extent, the shares that a scientific board will take can be negotiated. My preference always is to keep them in common stock because it keeps them on a level playing field with the early founders and investors, and there's really no reason for them to have preferential rights because what they're investing in is the company and the success of the company in large part measured by the work that they're providing. So I think common stock is a good currency for that. But if somebody insists and they can provide the value, you might offer some additional rights. It doesn't necessarily have to be built into preferred stock, by the way. You can have contract rights that replicate some of the things that you would find in preferred stock that would apply only to that person. And again, in an advisory board scenario, you don't necessarily have to have the same terms with respect to compensation or equity for each one. It should be a discussion and an evaluation based on what that specific advisor is able to bring in terms of increasing shareholder value overall.
But also these could be options as well, and not outright, issued shares as well, right?
Yes, that's correct. And I do want to talk about that a little bit because this is another trap that sometimes companies will fall into.
And maybe I'll step out until another question comes back, but maybe you can address maybe how much should be given to an advisory board, scientific or non-scientific.
Well, thank you, JJ. The first thing I want to say is that incentive compensation can be a tricky area. Normally, what you want to do is take a percentage of the projected total capitalization that you're expecting to give out. So if you fund the pieces that at that moment you're going to need to fund, whether it's today or tomorrow or next week, then what you do is reserve a portion of your authorized but an issued equity as an incentive compensation pool, and that number will vary. It's not a legal requirement, but I would say typically I'm seeing companies reserve anywhere from 12% to 15% of it for a total incentive comp plan, and that would include management awards, advisors, board members, certain key contractors, and your scientific advisory board or SAB. That's all included in that 12 to 15%. Now, in order to award incentive compensation, a formal plan, an ISO plan, an incentive stock plan, should be adopted by the board of directors, and it should also be approved by a vote of the equity owners, because it takes both pieces to approve a valid incentive plan. And I'm in favor typically of creating a plan that is as flexible as possible for the board to be able to use its discretion. So I will typically recommend a plan that allows for the issuance of both options, but also restricted stock grants so that you can issue either one depending on the circumstances of a particular award that the company wants to give. It is very important to involve a knowledgeable CPA when you're when you're developing these plans and monitoring them, because the CPA will be able to answer questions about how to optimize the tax benefits and ameliorate some of the unfavorable tax consequences that can occur with the issuance of either incentive stock options or restricted stock grants. And they will be able to advise on forms that need to be filed with the Treasury Department for people to be able to get the tax benefit of certain types of plans, and also to let you know when there are issues involving deferred compensation, which can sometimes occur inadvertently in startup companies, and if not dealt with correctly, it can come back and create financial nightmares, not just for the corporation itself, but for the recipients of the equity or the deferred compensation as well. And the other thing that is a trap, and I see this again over and over again, is that startups, because they don't have the cash to operate as they would like to, can be very free with giving away stock to people to induce them to either provide services, to be advisors, or to do other things that are helpful to the company. And to the extent that equity is currency, entrepreneurs need to understand that it should be treated as though, in giving a share of stock or a membership interest, it's the same as though you were paying cash for services, which means it's a compensatory transaction, and it's going to create tax ramifications both on the employer side and on the employee side or the recipient side. So if you are required to file a 1099 on a payment of cash for services to a contractor, you need to value the stock and issue a 1099 for that issuance of equity there. And the other thing is that sometimes we'll see companies giving stock almost as a gift, but corporations can't give gifts. And by that, I mean, if there isn't, with every issuance of stock, a commensurate value coming back to the company, then the directors who have authorized the issuance of that stock can be liable for corporate waste. And shareholders and investors in the future even may have a claim that, so much stock has been issued, it diluted the value of the stock that they invested in, but for no value to the company. And corporate waste is a breach of one of the fiduciary duties that officers and directors and controlling stockholders have to the company and to its shareholders. So it's very important that you have knowledgeable people that will help you to not only create the plan, but also monitor and watch for any issuance of shares to anybody through particularly the early stages of setting up the company, because it can have serious effects in the accounting, in the auditing, and in the financial condition of the company down the road if some of these traps are stepped into, and people don't realize the kinds of liabilities that they may be creating. Another issue in terms of composition of the board is making sure that in your selection of board directors and also board advisors, although to a lesser extent the advisors, but certainly board directors who are going to be responsible for the day-to-day management of the company, that you not only have people who are expert in whatever field you are counting on them to provide advice and information on, but also that everybody who comes onto the board or as an advisor clearly understands the vision that the entrepreneur and the founders had in forming the company, in bringing a technology to market. If there's a pivot, they have to understand the why and the wherefore of that pivot, because they will be making decisions in their voting that can significantly impact the ability of the company to achieve that vision. I've had companies as clients where they've brought on board members that actually are from competitor companies. And sometimes the thinking is, well, if we have a board member from that company, we're more likely to be acquired by them in the future. But it can have a negative impact as well, because in one case in particular that I'm thinking about, which was a pharma company, they brought on a member from a competitor, from a competing pharma company, and that board member, from the moment that they joined, they blocked any attempt really to commercialize the technology, because the board member had an agenda of wanting to keep that technology on the shelf so that it wouldn't become a competitor to the other company that he was serving. So you've got to be very careful to vet potential directors and advisors for conflicts of interest. We always recommend that before you engage a director and even an advisor, that you have a background search done to uncover potential lawsuits, bankruptcies, things that are disclosure items in your securities offering documents, and that will come up in an audit. But if you don't know about it at the time and you're surprised several years after this director or advisor has been involved with the company, it can be disastrous. So you want to definitely keep your board composition within the control and the domain of the company, and make sure that you're only bringing on board people who will help advance the vision and the business plan of the company, and not be adverse to it or be conflicted by it or do anything that would impair the company's progress.
A question.
Yes.
What are the best states to register as headquarter, and should be their layers before the LLC operation? So I'm not sure of the latter part of the question, but
yeah, I'm not sure what they mean by that. Perhaps they can clarify the second part of the question. But
yeah,
in terms of the jurisdictions of incorporation, and this is an area which is debated among professionals, there seems to be a predilection among investors, and particularly institutional investors and VCs, to use Delaware as a jurisdiction for incorporation, because at least the perception is, and historically the fact has been, that Delaware was a very friendly state for corporate actors, and that a body of law has developed in Delaware which is beneficial to corporations in terms of dealing with anything that they may come up with. But there are other people who say that the other states over time have regulated their corporate laws so that they're not materially different in effect from Delaware's laws. So you really need to look at what's going to be convenient for you in terms of operating your corporation or your LLC. And also you should have a CPA look at the franchise tax, because Delaware has a somewhat complicated franchise tax with multiple formulas for how to arrive at what's owed. And it's not always based on the net worth of the company, but it can be based on a number of shares and the value of the shares. And sometimes people will arrive using those formulas at a tax bill that makes them fall off their seats. And sometimes it's incorrect, or it can be one of the other formulas will bring it back down to a manageable level. But sometimes they pay through the nose for that quote unquote privilege of being a Delaware corporation.
I've
The
seen
other
it
thing,
many times.
yes, yes. And the other thing that particularly California corporations need to be aware of is that California law has developed in a way that the concept of quasi-corporation has come in. There's actually a statute in the corporations code which says that a California company where the majority of the shareholders, the business, and the assets of the company and its tax base are in California will disrespect the fact that you're a Delaware corporation and will impose on the corporation, a Delaware corporation, portions of the California Corporations Code, which are the very reason that people incorporated in Delaware in the first place. So you may go through the hassle of being a Delaware company, but then by virtue of where you're located, where your employees are, where your assets are, and where you're doing business, you may find that those state statutory requirements that some people found objectionable in the first place are now being imposed on you as a Delaware corporation. And so you have to have somebody look at the quasi-California corporation rules and measure where you are against that state.
Because you have to register as a foreign corporation if you're doing business out of California anyway.
And in any state,
In
yeah,
any
any state where you are either recording business or set up an office, have employees, you have to file as a foreign corporation qualified to do business in that state, and that is again going to increase the franchise tax that you pay, and ultimately the income tax that you pay based on where those things are.
I have another question. I have a question.
Yes.
You talked about restricted stocks. Can you maybe explain what that is? Or you mentioned it. You didn't really delve into it, but maybe you could talk. What is restricted stock?
So restricted stock is a term that comes out of the SEC regulations, particularly Rule 144 of the SEC, that says that shares that have not been registered for public trading are restricted. They have limitations on how they can be transferred and how they have to be dealt with. They're not free trading in the sense of stock that has been registered with the SEC to be on a public exchange. But the term I used was restricted stock grant, which is another way of giving compensatory equity to people that are through a plan, an adopted incentive stock plan or stock option plan, and those securities are actually shares of stock. So you need to be aware that you're giving stockholders, you're giving people the rights of stockholders, and this is sometimes an issue for corporations because if you have an employee and you give them a significant amount of shares in order to induce them to do work for you, there can be a problem if that employee and you part ways in an unfriendly manner down the road. And stockholders by state statute have a tremendous number of rights, including unlimited rights of inspection. They can make life very difficult for a corporation, particularly in California, but also in other states. And so in any kind of whether it's a plan or whether it's just by contract where you're issuing equity or something that could be exercised or converted to equity down the road to somebody that's an employee or providing some service to the company, we always like to make sure that there's a clause in there that allows the company to buy back the equity so that you don't end up having rogue employees or former employees out there that can create trouble for the corporation.
Hence the restricted stock. So there's a few more questions coming up.
Sure.
One, I'll answer quickly, and then you can answer the legal part of it. So one is for a startup medtech device company, is it better to have an LLC or a C Corp structure? So I will answer the C Corp part. Is if you're looking for investors to invest, they will only invest in a C Corp. Um, as far as having LLC versus C Corp, if you're not looking for investment, I'll let Ken respond to that one.
So limited liability companies are good forms of business organization because they're relatively easy to work with, and you can be very creative in the operating agreement in terms of the allocation of profits and losses and different rights within the company. But JJ is absolutely correct. If you're looking to go for more sophisticated forms of investment, or ultimately to become a public company, have a public exit, then you want to be in corporate form. And the good news is, even if you started out as an LLC, there are methods of converting into a corporation that don't. So you have the benefits of an LLC perhaps early on, but can be a corporation when it's needed to be that way. Or you can create a corporation and then simply have your operating LLC as a subsidiary of the corporation. And that way, the corporation is the one that issues the shares to investors, but derivatively, everything is still coming from an LLC. And we have found that investors typically are not concerned about that schedule as long as they understand the stock that they're getting and the benefits of the series that they're buying into.
Yep, that's really important. So we have one of the investors online who made a comment, and I was going to make the same comment, and I'm sure you'll agree with that, Ken. Dr. Lee, Roberta Lee, says investors are not going to be familiar with each state corporate law, so I would cautious about incorporating in states other than Delaware. Even incorporating in California is not ideal for investors. So I hear the same thing all the time, Ken, is that, you know what, just do Delaware because everybody's familiar with that. Attorneys are familiar with that, so they don't have to worry about the different nuances of each state. And investors say, okay, just do Delaware just because.
No, that's right. But I would say then you have to really be careful about those quasi-California statutes that I mentioned to you, because you may think you have a Delaware corp and have the benefit of that body of law, but in practice, it may not apply and it may not be honored by courts if some challenge comes up.
That's quite interesting. Okay, another question. What are the benefits of US-based companies versus international based companies like UK-based? Meaning you're incorporated in the UK and you're trying to, I guess, do business in the US. You still need to file as a foreign corp, right?
Well, typically, if you're a UK company, a UK technology company, and we've had many clients that are foreign entities, they'll set up a subsidiary corporation here, and they'll perhaps run their sales and marketing offices and sometimes distribution out of the US subsidiary. But at the end of the day, things get consolidated and the P&L goes back to the UK company. There are certain considerations, though, that you must be aware of if you are either a foreign company operating in the U.S. or a company taking investment from an investor overseas. There are a number of things to worry about. One is the tax treatment. You have to have a CPA who understands the tax treaties and the different arrangements and what the tax implications are, both here in the United States and in the country where that money is coming from, or where that parent company or investor is located. And also, there are regulatory scrutinies and bars in some cases to money coming in from overseas. We talked a little bit about the Biosecure Act, which is an act coming up that specifically is going to affect medical and life sciences companies and restrict where investment can come from But there are also OFAC is the Office of Foreign Assets Control. They maintain lists of countries that are sanctioned and individuals from many different countries that are sanctioned where you cannot do business with them or it's a violation of federal law. There are export licenses sometimes that you need to get before you can send your technology product overseas or license the technology overseas. And then there are a panoply of issues involving anti-money laundering and Patriot Act and things like that that have to be looked at carefully. So definitely bringing in investment from overseas, whether it's through a parent company or private investors that are investing in your company here, there are things to consider, and you should have a professional review all of those with you before you take that on.
All right. Three more questions in the pipeline. One is, can you speak to Canadian-based startup companies, a corporation, Canadian corporation in the U.S. vis-a-vis U.S. SEC and state registrations?
So whether you're Canadian or Chinese or Korean or from any other country, basically the creation of a subsidiary here is going to be the same. That there are not rules that are particular to one country versus another. If you're talking about a Canadian corporation actually operating from Canada into the United States, if they're selling securities, and we've worked for for companies like Canaccord that will offer Canadian securities in the U.S. or U.S. securities in Canada, then you must comply with the securities regulations in the jurisdiction where the investor resides. And it doesn't matter where the issuer is located in the sense of having to comply, but you have to comply. And there may be issuer issues as well in terms of the issuance of securities. The one thing specifically about Canadian operations in the US is there are some very egregious tax consequences that sometimes will happen when assets from Canada are placed for use in the United States. And so if that's the situation you're talking about, please make sure you talk to a CPA firm that is versed not only in US tax law, but also Canadian tax law, because again, surprises come up and it can be disastrous for companies that aren't prepared for it.
All right, we have a couple more questions. So I have a Texas, I heard that Texas has favorable set of rules or laws beneficial for startup companies in terms of liabilities, etc. What are your thoughts about that?
Well, I'm not a Texas attorney, but I do have clients that operate in Texas. The only thing I'm aware of is that Texas sometimes is less regulated across various industries than California is. But in terms of startup in particular, I'm not familiar with what this person is asking about, and you would need to really talk to somebody that can access Texas law and respond to that.
Yeah, that would be very specific. And whoever's asking this question, this is back to Roberta Lee's comment, and that's why investors just say, just do Delaware. That's what happens. All right. Sean is asking, how about LLPs as up layer of C Corp in order for founder act as GP but protected? I'm not sure what that means. I'll read it again. How about LLLP? I guess LLP. I'm not sure there's three L's as up layer of C Corp in order for founder as a GP but protected. Maybe you can clarify that, Sean. I'm not sure I understand that.
Yeah, an LLP is a limited liability partnership, and typically that's reserved only for law firms and other professional service organizations to have sort of a partnership that's got limitations on liability built into it, but you wouldn't use it in a commercial corporate context.
He's thinking to use it, to be the founder, so the founder becomes a GP, a general partner. Yeah, I'm not sure how that.
Yeah, it sounds like he's referring to a sort of a fund of fund structure where they operate as partnerships, and then there are GPs and LPs, and whether you're an LP or a GP defines the amount of liability that you may have. But in a corporate structure, it doesn't make sense. And again, I go back to what I said earlier, which is keep your cap table as simple as possible, because if you can't explain it and explain a good reason for it, investors typically will not be happy with it.
Yep. Okay, no questions in the pipeline.
Well, then another thing I just wanted to mention briefly, JJ, if we have time, is we had some discussion in the prior panel about independent contractors, and one of the issues that we started to touch on, but it's really important for entrepreneurs to consider early on, is that if you are contracting with anybody, and that's any kind of a contract. It could be an employment agreement. It could be an independent contractor services agreement. It could be a service agreement. But whatever it is, if you're contracting with somebody who is going to touch in any way the creation or the improvement or refinement of your intellectual property, you absolutely have to make sure that there is language in that contract that provides for a complete disclaimer of that person to any right, title, or interest in the intellectual property that they're creating. They are being compensated as a work for hire to develop or to touch your IP. And your IP, in many cases, is going to be your core critical asset. And we have had investors that will ask to see every single contract where a person has provided services to a company. And if they don't see that language is in there, making clear that there's no potential challenge to the ownership of the IP down the road, they simply will not invest. And that's a very difficult thing to do years after the person has left the company after providing service. So you've got to make sure that your contracts have that language up front, and that the only person who's entitled to ownership and title of that IP is the corporation itself.
Any other questions for Ken before we end this webinar on corporate structure? Okay, well, Ken, it is 11 a.m. We do have another panel that's coming up on university tech transfer at 11:30, which is in about half an hour from now. And then another one on specifically IP, intellectual property, patents, copyrights, etc., for life science companies. And that would be at 1 p.m. Pacific time. So please join us again. Don't go away. Come back. Ken, thank you so much. This was very insightful. A lot of information that is definitely needed to be learned by startup founders, and they need to, like we said on the previous panel, that having the right attorney, having the right firm, having the right legal documentations up front is hugely important, and you cannot take that for granted by any means.
Thank you, JJ, very much. And I would encourage, if anybody has any questions afterward, feel free to reach out to me. I'm on LinkedIn, and I'm happy to answer anybody's questions.
Thank you, Ken. Thank you all very much for being part of this. We will see you in another half an hour and maybe another couple of hours. Talk to you soon.